There are different types of borrowers. That could be individual borrower, partnership, into undivided family, companies, trusts and cooperative societies. The bankers deal. One of the main functions of banker is to lend. Necessary precautions, appropriate decisions, securing the securities, documents, follow-up, recovery are very important from the banker's point of view. Individual competent to enter into a valid contract, should not be a minor, not attain 18 years according to Indian Majority Act, or not attain 21 years if he is a ward under the Guardians and Ward Act. If the money is lent to the minor knowingly or otherwise by a banker, he cannot recover from him by legal means. One has to be very, very careful. If a banker lends money for the minor's expenses for purchasing of necessities of life, the bank can recover the money not from the minor but from the estate of the minor. If an individual is not of sound mind, undischarged, insolvent, in other words, the banker has to ensure that the lending is made to the person who is competent enough to enter into a valid contract. Partnership firm. Indian Partnership Act, persons agree to share profits of business carried on by one, all or any one of them acting for all. Partnership deed contains should be important. Registration not compulsory. For lending to a partnership firm, the banker needs to insist for registration of a firm, which is important. Opening of bank accounts, borrowing powers, operation details, all are discussed in the Partnership Act, should be properly understood and appropriately implemented. Acts of the partner shall be binding on the firm if they are done in the usual course of business of the firm, in the usual way of business and as a partner, that is on behalf of the firm and not solely on his own behalf. BDG and Company is an existing partnership firm. There are 4 partners. One of the partners' son, who is yet to become a major, has been taken as the 5th partner with the consent of the other partners existing. Possible, not possible, he can be a partner only to receive benefits, still he cannot be a partner. Though the person can be admitted to receive the benefits, he cannot be considered as a partner because minor cannot enter into a contract. So the answer is D is the appropriate answer. A partner cannot affect the transfer of immovable property of the firm unless expressly authorized. Insolvency of the firm, on receipt of notice, all transactions to be stopped and the court's instruction to be carried out. A partner of insolvency of a partner, fresh mandate authority from the other partners, confirmation from other partners to honor the check signed by the partner who is declared as an insolvent to protect the interests of the bank is important. A bank has decided to extend loan to a partnership firm on the mortgage of immovable property of the firm. In fact, one of the partners has been executing the bank documents. On verification, it has been found that this particular partner who is creating a mortgage has not been specifically authorized to do so. Banker will be in order. Banker will not be in order. Banker will be in order only when expressly authorized to do so. None of these. So here, since that particular person has not been authorized, banker will not be in order. Death of a partner. The partnership firm comes to an end on the death, insolvency or retirement of the particular partner or partners, as the case may be. Bank has to stop operations in the account to ascertain the liability of the deceased partner in the running account, cash credit or overdraft, and make his or estate liable for its dues. When Suresh has been admitted to the partnership firm on 13/8/13, he was a minor. He gave his consent to be a regular partner in the firm with effect from 13/10/13. He became major on 13/9/13. Identify from which date you would be liable. When he was a minor, he has been permitted to be admitted to receive the benefits of the partnership firm, and he was not a partner at that point of time. Later on, he became major. From the date of becoming major, within 6 months, he can give his consent whether he would like to become a partner or not. If he gives, accordingly it will be taken. Since here, he has become a major on 13/9/13 and he has given his consent on 13/10/13, Even though he has given the consent on 13th and 13, since he was admitted to the partnership to receive the benefits from 13/8/13, he would be considered liable from that date onwards. The answer is A. Into undivided family, there are different laws. Please go through. HUF is purely a creature of law, cannot be created by an act or parties. It consists of male members from a common male ancestor, together with their mothers, wives, widows, and unmarried daughters, bound together by the fundamental principle of family relationship. Women are also made members of the family as its male members. Women membership also inherits properties at par and treated as co-partners. The members of the undivided family are called co-partners. Senior male member is known as Karta or manager. By birth, a person gets the right to become a Karta or manager. No requirement of any consent from the other co-partners in this regard. And he is the person who is supposed to lead that particular family business. Liability of the Karta is unlimited. Liability of the co-partners is limited to their share in the joint family business or estate. Karta has the power, right to possession and management of the joint family property. Income from the joint family property, represent the joint family property, sell the joint family property for family purpose. These are the powers he has. Duties. Equally, he has got certain duties. Duty to run the family business and manage the property for the benefits of the family. Duty to account for the income from the joint family business and property. He is expected to have proper accounts to take care of the joint family property. Though the Karta is considered as an important person in the affairs of joint family, joint Hindu family, it is A. advisable to obtain the signature of the adult members as well as the Karta while opening a bank account. Same as mentioned in A is applicable while lending. C. It is enough if only Karta signs the documents. D. In addition to C, it is enough to intimate the other adult co-partners about the happening. B is the more appropriate answer. Banker has to be more vigilant while dealing with the HUF related matters. To know the Karta, to ensure that the Karta borrows for the benefit of the joint family only. Application for opening an account must be signed by all the members including the Karta. In case of lending to a HUF, the banker should obtain the signature of all adult members. They should be made jointly and severally, that means individually liable for any borrowings. The accounts ends in overdrawing. Companies. Other than your partnership, HUF, companies are also there. Before we move to the company, let us also understand the latest development as far as partnership is concerned. The concept of limited liability partnership has been introduced. In the year 2008, Act was passed and notified with effect from 31st March 2009. The Act has been notified with limited sections only. The rules have been notified in the official gazette on April 1st, 2009. The first LLP was incorporated in the first week of 2009, April. In India, for all purposes of taxation, an LLP is treated like any other partnership firm. LLP shall be a body corporate and a legal entity separate from its partners. It will have perpetual succession. Indian Partnership Act shall not be applicable to LLPs. Provision have been made for corporate actions like mergers, amalgamations, etc. The Act also provides for conversion of existing partnership firm into private limited company and unlisted public company into LLP by registering them with the Register of Companies. The Register of Companies shall register and control LLPs also. LLP is high-tech in the sense hybrid. It is a mixture of a partnership firm and a private limited company. In the case of a partnership firm, the minimum requirement is 2 and the maximum requirement or numbers, if it is a banking associated business, 10. Other than banking, it is 20. In the case of LLP, there is no limit. Other than that, LLP is going to have a significant aspect like limited liability. In the case of a partnership firm, every partner has got an unlimited liability. That means whatever the capital he has invested, he is liable for that. Even beyond that also he is liable. And in the case of LLP, that is not available. That is the reason LLP is taking shape of late. Now let us go to the companies. An artificial person, legal status, continuity, perpetual succession, common seal. These are the 4 aspects which define a company. These 2 documents known as Memorandum of Association, Articles of Association are the basic documents. They are called public documents. In addition, Certificate of Incorporation, Certificate of Commencement of Business wherever applicable, and resolution are some of the other essential documents associated with the companies. Memorandum of Association, it is a basic document, charter of the company. These are the other aspects like name, registered office, objects, what is the purpose, liability of the members, share capital and distribution are discussed. Articles is the internal document, powers of the officers of the company, subordinate to the MOA, that is Memorandum of Association, number of directors of the company, procedure for transfer and transmission of shares, borrowing powers, officers of the company and other details are dealt in. Both the documents are essential and the contents are more essential for the banker when he is going to lend to a particular company. You can have a look at it. This is the difference between a private limited company and a public limited company. Minimum means 2 members, like that it is written. Continuation. Identify the public documents. Memorandum of Association, Certificate of Commencement of Business, Certificate of Incorporation, Certificate of Commencement of Business, Articles of Association, resolution, none. The answer is none. The appropriate answer is Memorandum of Association and Articles of Association. In addition to the company, these are all also important from the banker's point of view. Whenever any outsider is going to use the money of somebody else, like clubs, schools and other non-trading associations, banker has to be more careful because outside fund is involved. So a banker has to study the bylaws and understand its contents without exception. Indian Trust Act, Public Trust Act and other things are applicable. Should acquaint himself with the respective laws applicable to them and should ensure that his lending is within the ambit of those laws. Trust funds are generally given under trust. Banker dealing with trust have to be doubly careful to avoid complications. Trustees, managing to manage the trust. Powers and duties provided in the trust deed, also regulated by the respective laws applicable to such trusts. Yes, next. A company has approached the bank for finance. The documents have been executed, but the common seal has not been affixed on the loan documents while executing. As we have already seen, company is an artificial person, legal entity, perpetual succession and a common seal. Affixing the common seal assumes greater significance. It is an evidence that the documents have been executed for and on behalf of the company, and if the particular articles of association is silent, then affixing the common seal is not a must. On the other hand, if the articles of association specifies, if it is omitted to be affixed, then it is not acceptable. So in this case, but the common seal has not been affixed on the loan document while executing, unless otherwise specified in the articles of association. Affixing of common seal is only optional, it is not compulsory. So one has to understand whether articles are specifically mentioned and which are the areas that common seal affixing is a must. If it is mentioned, accordingly it should be taken care of. Random basis. A partnership firm is different from that of a private limited company. True, incorrect, not true, false, true. Which statement is appropriate? A minor can be a partner in a partnership firm. In addition to A, with the consent of the existing partner. C, a minor can be admitted to receive the benefits of the partnership firm. None of these. C is the answer. We have already seen why a minor cannot enter into a partnership firm. The reason is